Okay, welcome to Learning Module number 3, which covers legal correspondence. I'm going to go over a PowerPoint at first, and then we're going to go over some other material that you will find in Learning Module number 3. So let's get started. As always, please be sure to read all the material that is located in the learning module that you are working on for this particular unit. So go through each one of the items, and you'll find sometimes that they don't always mesh up. For example, one resource may talk, I'll give you an example from this chapter, one resource may talk in terms of a block format, and other ones may talk about a modified block format. That's a healthy thing to see, because you're going to see that there's differing ways of doing things. Now, of course, for a class, we need to have one answer, and so I'm going to tell you the way I want your documents in this course to be prepared. But it's also a good thing to know there's other ways of preparing these documents. And you may well in your professional life be required to prepare documents in modified block format as well as block format as well as perhaps some other type of format. So it's good to know there's other ways out there, and it's good to know there's not just one way. But for the purpose of this class, in this video, I'm going to tell you how to prepare the document, because there's a couple of things in the sample document format that I consider incorrect. And so when we're going over this, if you find a contradiction between the material in the file, that Learning Module 3, and what I say in this lecture, please follow, so you can get your highest score, please follow the material that I cover in this lecture. Okay, so you want to take careful notes, because you won't want to hear this lecture 12 times. So take notes of the things that I've covered that may be different than the other material. In fact, it might be helpful if you were to pause this and go look at the material in the file first, and then when I say something that's different, you'll be able to immediately identify and say, okay, Gruber's saying something that's different. Let's get started. Both attorneys and paralegals routinely use correspondence to communicate with lots of different people. It's obviously used to talk with clients. That's an obvious one, so we're going to bullet number 3 down here. Let me actually. So they're used to talk to clients, very common. Obviously opposing counsel, and sometimes when we use the term opposing counsel, it sounds like, well, we're always in an adversarial position. Many times a counsel for the other side really isn't opposing. For example, let's say you're drafting a contract. And your client wants to enter into some kind of business relationship with the other guy's client. Well, you could say you're opposing counsel, because in some senses it's a zero-sum game. If your client pays $1 million for that item, then that's $1 million the client is paying. If the client pays $2 million, then that's $2 million the client's paying. So you can see how it's a zero-sum in terms of the dollar amount. And there can be specific provisions in the contract that clearly advantage one side over the other. But at the end of the day, if they're entering into a contract, they see that there are some pluses to the arrangement for both sides. So it's not completely an adversarial situation. In fact, many times it's not primarily an adversarial situation. So when we use the term here, opposing counsel, it means counsel for the other side, but it doesn't necessarily mean that there's an oppositional relationship. Then we have co-counsel. Co-counsel is someone different. This is somebody who represents the people on your side. For example, you might represent one company, and another company and your company are going in to make a bid for constructing something for a third company. And so you and the other company have a partnership relationship. So but it may be that the other company has a different counsel because the interests are not perfectly aligned. Well, that might be a situation of co-counsel. Or co-counsel could even be someone who actually represents exactly the same people that you do, but there's just more than one attorney assigned. And so you'll correspond, with court staff and also third parties, for example, expert witnesses, witnesses generally, court reporters, other people like that. And so you'll be using legal correspondence on a very regular basis. Now, in everyday personal matters, we probably use texting or emails more commonly than correspondence. But in legal writing, still it's probably more common to use email than correspondence. Attorneys and paralegals, though, still use a lot of legal correspondence. Part of the reason for that is that it can have legal significance. Let me go through a few reasons why legal correspondence continues to be the dominant way to communicate other than orally with other people. First of all, it creates a permanent record. An email also creates a permanent record, but people don't treat it as seriously in terms of it being a document. Court staff definitely won't look upon it as having the veritas, not veritas, the gravitas is the word I mean, that a letter would have. Another difference between legal correspondence and email is that people have different expectations about email. Email is casual, it is informal. People aren't too stressed about there being typos or there being imprecision in the language. It's a sloppier style of communication. Whereas when you're writing a letter that is typed, that has a wet signature on it, people expect there to be good grammar. They expect it to be well organized. They expect it to be without typos. You know, maybe in a long letter there might be a typo or 2 typos, but if it's a short letter, any more than 1 or 2 would be pretty much out of the bounds of what's considered acceptable. So there is an element of formality and seriousness. There's also an element of respect. The court expects that you treat it with a great deal of deference and a great deal of respect. Also, your clients who are paying you a lot of money expect that level of dignity. And if you want to have a good relationship with opposing counsel, again, you ought to extend that to opposing counsel. But there are other reasons people use legal correspondence versus an email, and I'll give you one of the big reasons, which probably people don't talk with their clients as much about. But if I were to send an email to my client, let's say I were to say, I recommend that you settle your claim against ABC Company for $10,000, and these are the reasons why I think this is a good proposal for you. And I write it up. I write a brilliant letter. It's well organized. There's no typos in it. It's everything that you would want a letter to be, but I actually put it in an email. You may be thinking to yourself, well, why not? I mean, it seems to accomplish the same task. And let's assume my client loves getting emails. That's his preferred style of communication. So I send it to him in an email. And he's maybe not the most sophisticated client, or maybe he is. Maybe he's a little cocky and he thinks he knows more than maybe he really does. He gets a letter and he starts thinking to himself, gee whiz, I'm excited about this piece of news. I want to share it with my great Aunt Mabel, or I want to share it with my buddies who I went to college with. They'll think this is great news. Or maybe the client is mad. I can't believe my attorney's recommending this, or my paralegal is telling me that the attorney's recommending this. I want to run this idea by one of my buddies and see if he thinks it's reasonable. So the client can very easily forward that email to everybody in the world. Now what you sent, you the paralegal or you the attorney sent the client, was an attorney-client privileged communications, because you didn't send it to anyone else who wasn't in that relationship. But an email is so easy for the client to forward innocently without really any level of reflection. He has now waived the privilege. Even if he doesn't send it to anyone who's even possibly going to send it to opposing counsel, it is still possible that because the privilege is waived, opposing counsel may be able to get that email and maybe even be able to get other communications. So you have put your client in a very difficult position, possibly in a very legally vulnerable position. And you may say to yourself, well, all I have to do is just remind my client that they can't forward it. Well, there's several problems with that. First of all, it would be wonderful if we lived in a world in which clients did exactly what we want. And if you ever find clients that do that, you are a very blessed person, because that is not ordinarily what clients do. Even when clients think they're doing what you want them to do, many times they aren't. And keep in mind that you may have had a lengthy conversation with them on day one about never forwarding emails, but 3 years have passed. And guess what? That discussion has completely slipped their minds. And if you remind them about it, they may be sheepish and say, oh yeah, I do remember that. But guess what? In the thrill of the moment, or in the anger of the moment, they've forgotten it. Even if you have a footer on your email, which you almost certainly will, which will say, don't forward to anybody ever, 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 no one reads those. So the bottom line is, you can't count on your client remembering, and even if he does remember, you can't count on your client following that good piece of advice. So sending emails is not the best idea ever. But there's some problems with emails even beyond the fact that you probably have a client that will misuse email. Another problem is that we are all creatures of an email culture. So when you write an email, you work under the assumption, which is terribly wrong, but we all do it, even I do it sometimes, that it's kind of a throwaway message. It's a text message. It's not something that's enduring. Reality is that email messages are maintained essentially forever, as are text messages. They can't be recovered. And so even though we may be treating it as a very casual note we're dashing off, it has staying power, it can be subject to discovery, and it also creates an impression. Oh, okay, she didn't care enough to spell check. He didn't care enough to use good grammar. She didn't think enough of me to arrange the thoughts carefully. So if you're going to spend enough time to write a letter, in order to write an effective email, you have to spend enough time to write a real letter. So why not go ahead and write a real letter? There are times that emails can be effective, and one time that they can be is when you're sending an email that is really just call me or we need to get together. The idea behind this email is you don't even say what it's about. It may be obvious in the context. We need to discuss a development in the case or something along those lines. Well, maybe the client will immediately know what you're talking about. But even if the client forwards this email to the world, and you probably won't because it's not especially interesting, the privilege probably hasn't been waived. So you can send a note saying, call me, we need to meet, or something along those lines. An email like that or a text like that is probably going to be okay, but you don't want to get into substantive matters except in very, very unusual circumstances. Correspondence isn't used for inter-office tasks. So if I'm communicating with somebody in the office down the hall, or even if it's a big corporation and this is somebody across the country, you usually don't send a legal correspondence. You can just send an inter-office memo. Now, an inter-office memo may be very different than an email. I'm not saying that inter-office communication and email are necessarily the same thing, but it wouldn't be a legal correspondence format. You'll want to follow the rules in your law firm about when you send legal correspondence versus when you send emails. Certainly, emails have become more accepted in the legal profession than they were, 20 years ago, but they aren't as accepted as legal correspondence. Oops, excuse me. I have included a legal correspondence letter in the sample documents file. That document is, generally speaking, a pretty good example, but there's one glaring error in it. And so I'm going to talk about that as we go forward. Law firms do vary how they prefer their correspondence to be formatted. It is true that modified block is probably the most common format for law firms, and that's the one we're going to use. So in this class, modified block. Now, you may go back to work tomorrow and say, or your law firm may say, we use block. Absolutely perfectly fine. Nothing in the world wrong with block. In fact, I prefer block. But for my studies, it seems that modified block is still slightly more common than block. So for the purpose of this class, we're going to learn modified block. So use that going forward in this class. In your other life, you use whatever your firm wants you to use. Let's look at the parts of a legal letter. Well, first of all, you got to have a date. This is the date that the letter leaves your law firm. You might actually write the letter and sign it on June 7th, but it doesn't hit the mailbox until June 8th. Then guess what? It ought to be dated June 8th. You ought to list the mode of delivery unless it's first-class U.S. mail. If you send it by first-class U.S. mail, which is the ordinary way that you send U.S. mail, you don't have to specify it. That's the default setting. But if you send it overnight or FedEx or UPS overnight or whatever, you need to list that. And if you're sending it another way through U.S. mail, for example, U.S. mail return receipt requested, you need to list that, certified mail return receipt requested. And you also need to list a tracking number with it. So this is also included in the letter. Then you have an inside address. This is the address that the letter is going to. Now, obviously, you'll need to also put this on the outside envelope. Then you need a reference line, which you could also call a subject line or array line. Either term is fine. In a very short letter, it's possibly you won't need this, but you will find the vast majority of times you will want to use this. It helps lots of different people. Number one, it helps if you're the person who files your letters, making sure that your letter goes into the right file. So you would include perhaps the name of your client or the matter number. It may just be an internal filing information that's going to make your life easier. If you don't file your actual letters or documents, you're helping someone else file correctly. And this can be important because let's say you don't include enough information and the person guesses and they guess wrong. Well, you may never be able to find the original copy of the letter. It could be important. So you're helping yourself maintain the file appropriately when you put a reference line that's appropriate. Again, this is something that you'll look to your style manual of your law firm to figure out how this is actually listed. It can also help the person you're sending the letter to so that they can make sure several things. Number one, they can make sure they file it in the right file. Number two, it can also help them immediately key into, okay, now why am I getting this letter? What's this letter about? Kind of get them in the right frame of mind. And if it's an especially urgent matter, when they see the subject line or the reference line, they may immediately say, oh, I've got to make this my first priority. So it can be helpful from that standpoint. It is a courtesy. It doesn't have to be done every single time. But for this class, you ought to have it. And you'd probably find 95 to 100% of the time you'll use it. Then you'll have some kind of salutation or greeting. Almost always this is going to be dear, then Mr., or Ms., M.S. period, or possibly Dr., and then the surname, and then a colon. We never use a comma in professional writing. We would only use Miss or Mrs. if we have a reason to think that the person to whom we are sending the letter would prefer that. Our default setting for women who are not doctors should be MS period. If we are dealing with somebody whom we are not sure of his or her gender, then we ought to list the full name. For example, Pat Green. We don't know if Pat is short for Patricia or Pat is short for Patrick. Then we would say, Dear Pat Green. Sometimes this comes up with individuals whose surnames or names might be from a different culture. We may also not know which one is their family name, which is the first name on the name, their family name, or their second name. In different cultures, it can be different answers. That would be another situation where we might want to list, even if we knew the person's gender, we might want to list Pat Green because we might not be sure Pat is the personal name and Green is the surname. Then we have the body of the letter. This is the bulk of the letter. This can go on for several pages, or it can go on for as few as 2 paragraphs. You always want at least 2 paragraphs in your letter. We'll talk about this in a little bit more detail going forward. Then we'll have the signature block. Again, your law firm will have a rule about how you close the letter, but a very common signature is very truly yours. Now, when you hear this, you may think, well, gee whiz, that's a little treacly. They're not very truly mine. This might be my opposing counsel. I might despise them. It's a kind of a fake expression, but it's one that you'll routinely see. You're not really promising your undying loyalty to them. Your firm will have a set phrase that you use. Some law firms will actually put the name of the law firm right below it. Then there's a space for you to write your name, and then you'll have your actual name, Cynthia Groover. If you're an attorney and you're writing a law firm stationery, you don't need to include anything else. If you're anyone other than an attorney who is signing a letter on law firm stationery, you'll need to put your title, paralegal. And you'd probably put it on another line. You probably would not put it after a comma, but I've run out of space here. Then, of course, you'd end with an enclosure if you have one, or attachments. And we'll talk about preparer notations in a minute. Let's talk about the mode of delivery. It's a helpful tool. It helps you remember how you sent it so you can confirm it. Let's say it never arrives at its destination. Well, if you've written your tracking number down, you'll be able to track it down and see what happened to it. And if it becomes a question of fact, you can show how you sent it to a particular place to verify that, yes, in fact, you did send it. As I said before, you ought to include the tracking number if it's the type of device that allows it to be tracked. We are talking about the reference line. It's a way to allow the reader and the sender, as well as anyone filing it, to know the subject matter of the correspondence. When we're doing modified block, the reference line should be indented, and it should be limited to 1 line when practical, although it's quite common to have 2 lines. Let me show an example, and 2 lines is fine. You might use your first line to describe the particular issue. For example, summary judgment motion. Then the second line, you might include the information about the case or your file information. Let's say it's Smith v. Harris. Is the style of the case that you are writing the summary motion regarding. You might even need a third line to reference your particular file. Let's see your file, because you represent Smith, is SMI-107. So you could even use up to 3 lines of text. So don't be too worried if you get over the 1 line. The main thing to keep in mind is you want these to be pithy. Everything you put in your reference line or lines ought to be focused on, is this going to make it easier for somebody either to file it, to understand, or to understand what's going on in this document. And if it's accomplishing that purpose, don't worry too much if you have more than 1 line. Tone. Letters should be formal. This is not a chatty thing. Now, this doesn't mean that you can't have some kind of greeting that is friendly, especially if you've known this person for a while, especially if it's a client. You might well want to start with something warmer, but still the tone ought to overall be a formal type of communication. As I said before, you ought not do the Dear David. You ought to go with Mr. Brown with a colon. You can sometimes in a formal letter, if you want to warm up the tone, you might even do a handwritten comment. David, let's keep in touch, or something like that you handwrite on it, which kind of takes the formal tone of the letter and then makes a personal statement. You also ought to avoid the passive voice in drafting letters. This is not the best mechanism. In fact, it's truly not good for any legal writing, or really any writing at all. This is not the presentation where I'm going to spend, I'm going to spend a lot of time on the passive voice. But passive voice, let me give an example. An example of active voice is, the dog bit the boy. The first verb in the sentence is dog. First noun in the sentence is dog. And the dog is doing the action of the sentence. It's doing the biting. The boy is receiving the bite. He's the recipient of the action. If I say this, the boy was bitten by the dog, you immediately know that the boy is not doing the action. He is, even though it's the first noun in the sentence now, he's still receiving the action. And the dog, who's in this by clause here, is actually the actor in the sentence. So this is active voice, and this is passive. One of the things about passive voice is that this by clause that I have included on here is not grammatically necessary. So I'm going to cross this out, and you're going to see that the sentence still is grammatically correct. Passive voice is not incorrect grammatically. It's usually just not as good as active voice. Now we have the boy was bitten. But again, a big part of the story is missing. Well, who bit the dog? Was it a python? Was it a cobra? Was it a spider? Was it a mosquito? Was it another child? Lots of questions. I mean, our response to the situation of the boy being bitten is going to be very different depending upon whether it's a dog or a cobra or whatever. So this doesn't give us as much information. But sometimes we don't have the information. Maybe we don't know who bit the boy. Maybe all we're seeing is the blood pouring out of the boy. It could have been a dog. Maybe it was a bobcat. Who knows? And so when we don't know the actor, we might well use passive voice. Or when the actor isn't especially important. Maybe we're responding emotionally to the boy being bitten and bleeding. And so that's what we're focused on, not so much thinking or caring about who did the biting, but just concerned that the boy is injured. So passive is not wrong. Passive is not grammatically incorrect. There are times where passive is the best way of saying something. But most of the time, probably 90% of the time, we want to use active voice. So we want to look for that. So if our first verb in the sentence is the actor, is doing the action, we have active voice. If our first verb is receiving the action, if we see a version of the word to be with a past participle, and past participles usually end en or ed in English, and that's an indication we're in passive voice. And we ought to challenge ourselves when we're dealing with passive voice. Is this the best way for me to write this? Okay. So here's an example of passive versus active. The lawsuit in your case has been prepared. So we have been here. So we have our to be verb. And we have the past participle, which ends ed. The lawsuit isn't doing anything. The lawsuit is receiving the action of being prepared. But when we read this, we don't know who's prepared it. The lawsuit in your case has been prepared. Well, if I'm sending this letter to someone, does it mean that I, the sender of this letter, prepared it, or someone else in my office has prepared it, or another law firm has prepared it? It's not at all clear. The next one is will be filed tomorrow. The lawsuit will be filed tomorrow. Well, who's going to file it? The lawsuit, again, is receiving the action of being filed. Again, we have the passive voice, the to be verb here, and the past participle right here. But we don't know who's filing it. Am I, the person who's sending the letter, committing to you, the client, I will file your lawsuit? Maybe I am, maybe I'm not. So a better way of saying this is we have prepared your lawsuit and plan to file it tomorrow in court tomorrow. So this provides more information. This is a better way of writing it. It's also easier to understand, and usually active voice sentences are shorter than passive voice sentences. So it wins all the way around. Signature. Again, I already repeated this, you have to disclose your role in all legal correspondence unless you do so earlier, but it's best if you do so earlier, also do so in the signature line, because this possibly exposes you to a claim of the unauthorized practice of law. Because again, the letterhead of a law firm, if you sign it without that disclaimer, you are implying that you are an attorney, and so if you said something that might possibly be legal advice, it could put you over into unauthorized practice of law. If you're preparing the letter for an attorney to sign or for someone else to sign, then we'll talk about listing your initials. And this is the one area that the sample letter gets wrong. So we're going to talk more about the author's initials in just a second. But be aware, if you're not signing the letter but you've written the letter, you have one more responsibility to do with the letter. Okay? Most of the time, your correspondence will be one page long, but occasionally it will extend more than one page. If that is the case, you only use the letterhead for the first page of the letter. The second and any subsequent pages need, though, for it to be clear that it's whatever page it is the letter and that it's related to that first page of the letter. There's a variety of ways to do that, but usually you're going to include something about the page number and either letter to Mr. Green or whomever the letter is to. So I guess I'll fill out letter to Mr. Green, or letter, Ray, summary judgment motion, or some description here so that somebody who, let's say the individual pages of the letter have gotten separated somehow, someone who's responsible for filing can figure out how the pages of the letter fit together pretty readily. You can also include, as I say here, the day of the letter. That's another handy way. So you could say letter to Mr. Green, dated whatever the date is. Each paragraph in the letter should have at least 2 sentences. The one exception for that is the closing paragraph. As I said before, each paragraph, or you need to have at least 2 paragraphs in your letter. But sometimes you really don't have 2 paragraphs of stuff to say. Let me go back to the previous slide here. Let me go back a little farther. Let's say this is all you have to say. We have prepared your lawsuit and plan to file it in court tomorrow. Please contact me at this number if you have any questions about your case. Let's say we don't have anything else to say. Well, guess what? We are going to have to separate these into 2 paragraphs. So I'm going to put a little paragraph sign. So this will be 1 paragraph. This will be the second paragraph. Now, we actually want to figure out one more sentence we could put in the first paragraph. But our last paragraph, we can just have it be, please contact me if you've got any questions. You know, having the final paragraph be 1 sentence long is not a great tragedy. You do want to figure out a way to have at least 2 sentences in your first paragraph. So that's just a stylistic thing that you ought to keep in mind. Think about your audience. Who are you writing to? Is this a sophisticated attorney or court or opposing counsel? Well, then you may feel more free to use legal terminologies. If this is an unsophisticated client or someone else who might be intimidated or confused or not liking the terminology that you use, you may want to adjust your terminology somewhat. If you're sending a cover letter, and we'll talk about this not so much today, but we'll talk about it later in a presentation. When you send a cover letter, keep in mind that the court clerk really isn't reading it. It's just a courtesy copy to show what is being included in it. So there's really no point in getting too flowery or providing so much information in it, because really the court clerk is going quickly to the substance of the document. And you're really wasting your time. Of course, if you're wasting time when you're a legal professional, you're wasting money of your client. Paralegals should carefully consider whether and when to transmit copies of correspondence to third parties. Let's pause here. There are two ways you can send copies. One is CC and one is BCC. Let me pause here and talk about something that is kind of ancient history, probably for many of us that are watching this. When I learned to type, I actually learned to type on a typewriter in the dark ages. And we would put CCs on letters. And back in this day, it was just before Xerox machines were very, very common. And so sometimes secretaries would actually not photocopy a copy of something, but would instead use carbon copies. So they would have a piece of paper, then they would put a piece of carbon paper, which is a piece of paper that it has a thin coat of carbon on it, and so when the key of the keyboard, of the typewriter hits the top page, it would also hit the carbon paper, and the carbon would be released onto the page underneath it, and so you would have another copy of that paper. So when you say CC, historically you meant that the person that was going to get the CC was going to get the carbon copy version, which usually was less pretty because the carbon copy was a little bit less precise, and it was kind of a second nice copy. Another term that that CC can stand for is courtesy copy. And this means you're not getting the original copy. You're not the person that the letter was written to, but as a courtesy, for some reason, I want to give you this copy. Sometimes people, instead of saying CC, will just do C, meaning you're getting a copy. Either one of these is perfectly fine. Now, one thing about a CC is that when you are CC'd on a letter, the person who was originally addressed the letter to, let's say I'm writing a letter to Bob Smith, and I CC Mary Green on it. Well, Bob Smith is going to see that Mary Green is getting a copy, and Mary Green sees that I wrote the letter to Bob Smith. So everybody knows about everybody in that situation. Now let's talk about BCC. The B here stands for blind. So you can think of this as blind carbon copy or blind courtesy copy. And again, sometimes people put BC, meaning not before Christ, but blind copy. And what blind means is that the person who got the initial letter, we'll say John Green, the letter was initially addressed to, he doesn't know who's getting the BC. He doesn't even know if there even is a BC copy or BCC copy. The BCCs will see who the letter was originally addressed to, John Smith. The BCC will also see, the CCs will see that Mary Green got a copy of the letter. But neither Mary Green nor Mary Smith nor Bob Green, the person who the letter was written to, will see the BCCs. You may think, well, why do you want to send letters clandestinely? Well, first of all, I'll start by saying is there's nothing unethical or improper about sending BCCs. They are extremely commonly done. I would say probably a third of all letters that go out from a law firm have a BCC, and they're very, very common. So there's nothing untoward about it at all. Many times they're done to let people in the chain of command know, hey, I've already sent that out. It can be an easier way of communicating information than sending out a separate note saying, hey, Bob, I mailed that letter today. He can see it's been mailed when he gets his BCC version of the letter. It just may be, well, nobody else needs to know that I'm BCCing this to Bob because they don't need to know that Bob's involved in this. Sometimes law firms like to BCC clients. Their idea might be, well, if we made it obvious that the client is getting a copy of the letter, that is in some sense communicating information to the client. And if we do that, possibly we're waiving our privilege. And so if we send it BCC, if we're sending, say, to opposing counsel, the letter is addressed to opposing counsel, and we BCC our client, then we're keeping that confidential. Is that necessary? Probably not, but there's no reason why you shouldn't do it. No one outside the law firm should receive copies of letters to clients, so you never should CC or BCC a letter sent to a client if you know, because that could waive the privilege. We've already talked about BCC. When you do a BCC designation, you would do this on another sheet of paper so that you could have the BCCs listed on that piece of paper. You won't have any BCCs in this particular assignment, but I want you to be aware of the concept. Generally, keep in mind you can be tested on that when it comes time for midterms and final exams. So now we are going to go to my desktop. Okay, so here we go. I'm going to go first to sample correspondence. This is the one that you will find in your sample documents folder. Let's look at some pieces. This first section up here is the letterhead. Actually, from here down to all this that I have, oops, here. All this is, and also including, actually Daniel's name is misspelled. You wouldn't want to do that, but imagine that Daniel's name is correctly spelled. All this is the letterhead. In most law firms, you're going to have this printed. So you will be given this sheet of paper with this already nicely embossed upon the paper. You will only use letterhead on the first page of the document. All subsequent pages you're going to start with blank paper if your letter extends more than one page. Now some law firms that are newer, may have less of a budget, may not have printed letterhead. You may actually have a template so that each time you do letterhead it will actually print upon a blank piece of paper. And so you would obviously have some template where you'd work from this point of view. The next thing you're going to have here is the address. Let me see, the date. You see here it's centered. Let me pause here and go into, let me open up a Word document. Take me a second to do this. So I'm going to, first thing I'm going to do is I'm going to come up with a letterhead. And of course your letterhead is going to be centered, so I'm going to do this. I'm going to say Smith and Green LLP. Oops, wait a second, it's not going to be like that. I'm going to change here so we have remove space after, and I'm going to say it's 12312 Main Street, Allen, Texas, 7502. Telephone 214-123-1234. Facsimile 214. 123-1235. I'm going to make it bold so it looks a little bit fancier. Your law firm will have a much nicer letterhead than this, but this serves the purpose. Then I'm going to drop it down a couple of spaces, and now you see I still have it centered. If I wanted to left justify something, it's go over here. If I want to right justify, it's over here. But I want this middle one. I want it to be centered. I've taken away the bold. Now I'm going to go to my normal font, which is 12 point. Remember, in this course we use Times New Roman 12-point font as our default setting. So now I'm going to type in the date, June 15th, 2014. There I've accomplished the date function. Let me go back here. Now I'm going to send this via certified mail. You can see we're going to need to left justify this. Excuse me, right justify this. So I'm going to go to the next line. I'm going to click over here, right justify. Now, in this particular example, the writer has made it italics. I'll capitalize it. And in this example, they've also chosen to make it bold. We're going to do the same thing. For our style book, it has these same features. So when we're referring to our style book, we're going to use this. Now we are going to go, now we're going to do the inside address right here. So a couple of other returns. I'm on right justify. I need to go to left justify. Now I need to type in the name. The better practice Again, there's a couple of things about this format that is not a best practice. Best practice is not to say Stephen Young. It's to say Mr. Stephen Young or Dr. Stephen Young or whatever. So I'm going to do it correctly. Mr. Stephen Young. And I'm going to say he lives at 432 Broadway Avenue, McKinney, Texas, 77070. Oops. 770. You can see I still have it on bold and I still have it on italics. Don't want that. So here we have our nice address. You can see here they don't have it italicized, they don't have it in bold. Now we get to our ray line, we can see it's indented. Oh, we need one more line in here. And so I'm going to say Ray, your legal bill for May 2014. And again, I'm going to periodically save my document. I'm not going to save it now, but just remember, when you're writing documents, routinely save it every couple of minutes, or save it so that you won't end up losing a document, obviously. So we say, Dear Mr. And you can see the way I have this set up is I'm going to blow this up just for a second so you can see it a little bit clearer. I'll make my font this big. You can see all of these dots are in here, and you can see when I do a tab. You can turn that off if it's annoying. All you have to do is hit this paragraph sign and it goes away. It's probably better to edit your first, or to do your first draft without that being turned on, because it can be kind of annoying. But before you send it out, you ought to turn that on to make sure your document is formatted the way you want it to. And you're going to have a hard return to get down here. We're going to indent. This we ought to be directly below the ray. You're going to type your letter. Again, this is modified block format, so I'm going to indent saying, enclosed, please find your bill for May 2014. It has been our privilege to provide you with legal services for this month. So I managed to come up with 2 sentences here, but you say if you're unhappy with me, I have this green because remember we decided last time we're only going to do 1 space for paragraphs. I have to indent again. If you have any questions, please contact me, and I'm going to hit return. That's my whole letter. Again, I routinely send bills. This is not an unusual thing for me to do. Now you can see here we're going to do sincerely. Now this I could center, but these I'm not going to be able to center. I'm going to have a tab going on. So I'm going to tab, 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 tab. I'm going to want it to be about the middle of the page. I think this will work. And so let's see, the language that we have is sincerely. Sincerely is also fine. Sincerely, comma. And this we're going to say is, well, I'll just say Cynthia Greer. My next line, because I'm a paralegal, and this is on law firm letterhead, I have to indicate some way that I'm not a paralegal. I can just say paralegal or legal assistant, or I can provide more information. Paralegal to James Smith or whatever. I'm just going to stick with paralegal. If I put paralegal below Groover, I don't put a comma here. If I put it up here, I put a comma. The better practice is to go to the next line. Now, if I were using some kind of abbreviation, let's say I have my CLA, I could absolutely do that. Cynthia Groover, comma, CLA. But I don't, so I'm not going to put that there. Now, this is the area that I disagree with what has been set up here. And actually, now that I'm thinking about this, I'm going to recommend that you not center this. I'm going to recommend that you tab this so it lines up with this. So instead of centering, we're going to line this up so that the J in June is right above in a horizontal, a vertical line, the S in sincerely, the C in Cynthia, and the P in paralegal. And now we're ready for the initials here. This is wrong. What this says is incorrect. This makes it look like AMM, presumably Archie Manning, is going to sign this letter, and EM, presumably Eli Manning, actually typed the letter. But this is set up for Eli Manning's signature. So if instead it had said sincerely Archie Manning, who presumably is an attorney in this law firm, then this would have been correct, AMM \EM in lowercase letters. Now if I typed this letter and I'm signing this letter, there's no need for initials. The assumption is if there are no initials, the person who signs is the person who wrote it. But let's say I have a secretary who I dictated this letter to, or I wrote a letter and she signed or she typed it up. This is how you would do it. My name would go first, CFG, the initials that I've used in the letter, and they would be capital. I would do a \, and let's say that Megan Green typed the letter. In lowercase letters, we'd use MG. Most commonly, the person who signs a letter, 3 initials are going to be used for his or her name, and 2 lowercase initials will be used for the secretary's name. There's nothing wrong with it there being 3 initials. We'll say it's MSG. Well, that's a spice. Let's not do that. MRG. And there's no reason why it couldn't be CG if I, for whatever reason, chose not to use my middle initial. But you would want to have mine caps and then the typist in lowercase. The reason for this is, let's say that there's some question about how the document was typed. Maybe there was some context, or some material missing, or there was a typo that was legally significant. You'd want to be able to figure out who typed it for that purpose. So that's the reason for it. Most of the time you're going to find today that you're going to be typing your own document, so you don't need this. But the takeaway is for this is if Eli Manning typed this letter and he's going to sign it, this shouldn't be on here. If Eli Manning typed this for Archie Manning and Archie Manning is going to sign it, then this should be set up for Archie Manning's signature. So the problems with this are that that's really the only thing I would say that is wrong about this. I guess the things to keep in mind are that this isn't, we're not going to center this, we're going to make this flush with this down here and to use those initials correctly. So this concludes our discussion of the sample documents. Now we're going to go to some other documents that were in Module 3. This one is the plain language legal writing. Plain English is a big movement amongst not just legal writing, all writing. You'll find this in virtually every serious discipline in which writing is an important part. The plain English movement, though, has definitely made some significant inroads in the legal area. Once upon a time, I would say before the 1980s, and maybe even a little bit before then, it was very common for legal writing to be very bloated. There's lots of historical reasons for that. One reason that it used to be very bloated and difficult to read was that once upon a time, a very long time ago, attorneys were not paid by the hour. They were paid by the word. Well, you can see how that sets up really an unappealing incentive system. So a document that could be legally sufficient, that's maybe only a couple of pages long, it really motivated the legal scholars to make it as long as possible so they could get more money. That's no longer the case. It hasn't been the case for hundreds of years, but that mentality, I guess, is sometimes behind what we see things. Another reason that legal writing is often bloated is that attorneys and paralegals rarely work from scratch. They almost always use some document that they've used in the past or they've borrowed from someone else. And so when they get a document, they're going to add to it more so than remove it. I mean, they'll remove stuff that's obviously not relevant. For example, the names of the parties, if the names of the parties are different in this transaction, or specifics that relate to that transaction. But the boilerplate, which is the stuff that is canned, that is used over and over again, attorneys will rarely remove it. And the reasons for that are twofold. One is that attorneys are very almost superstitious about removing language because they can't see a reason why it's there, but if they remove it, maybe that somehow messes up the deal. Why take the risk? Why spend your client's time to remove stuff that's not doing any harm and might actually be doing some good? And think about it. If you remove something that ends up, it should have stayed in it, you could get sued. You could lose your practice. So the idea is a very conservative one. If it's there and the guy before me used it, why should I take a risk by removing it? The second reason that people don't like to remove language is that there's a notion out there that if it sounds long and bloated and difficult to understand, that the client will be impressed. The client will look at it and say, gee whiz, I have no idea what this says. It must be really, really hard to write. It must require somebody who's really bright and really knowledgeable to do this because I can't make heads or tails out of it. And so the more stuff in there, the more the client may think, I'm getting my money's worth because I can't read this on my own, so this person must be really, really smart. Nowadays, though, the trend is to do much, much less of that, to move much more into the area of writing text that is easy for everyone to understand, because really when it's easy to understand, it's also easy for the jury to understand. And usually juries are the ones who decide what the language in the contract means. And in fact, it is harder oftentimes to write clearly and precisely and plainly than it is to write in the bloated style of attorney. So keep that in mind. There's definitely been a sea change. Unless you're working with a very mature attorney, somebody who is close to retirement age, that the attorney with whom you are working has probably been told about plain English. Maybe not use that word, but they know they shouldn't be adding all the heretofores and part of the first parts and all that kind of silliness. So you shouldn't be working with very many attorneys who have the old-fashioned style of writing, and try not to adopt that kind of old-fashioned style because it's not up to date. It's not what attorneys are expecting from the paralegals. It's not what judges are expecting from attorneys. So let's talk about some things that this link talks about with respect to legal correspondence. You want your purpose to be very clear. This might be on the reference line. This might be in your first sentence of your letter, but you want it to be clear. You want for the reader to know what you're getting at so that he can be ready for it. You want to consider your reader. Is my reader sophisticated? Is my reader very busy? Am I trying to ask a favor from this person? Am I giving this person bad news? And is this opposing counsel and I've got to tell him that he's off base on this point or that point? You ought to organize your letter for the way that you think is going to be most effective. If you're trying to settle a case, you probably are going to want to try some tough love and some maybe more genuine love. For example, you'll want to point out the weaknesses in your case, but you don't want to tick off the other guy so much by pointing out all the bad things in the case that he's getting really, really mad at you. So there's a careful balance. You want to say, we want to settle, we think we can do this, but hey, you got some bad facts, so that means, it's going to be some money. There's a balance there. On the other hand, if you are creating a letter that you plan primarily not to get peace with the other side, but to show to a jury, then you might do fire and brimstone, something very, very powerful, because your real audience isn't the person who you're sending the letter to, it's that potential jury. So think about who is your real audience. Who is the person that you want to be moved by what you're saying? Think about your words carefully. Words have a lot of subtle colors of meaning associated with them, and it's helpful to think through those dynamics. Many attorneys consider themselves wordsmiths and have a lot of subtlety about how they write. Be aware of that. The more likely that you have somebody, attorney like that, the more important it is that you invest in choosing the right word. Not the good enough word, but the right word for that particular case. Okay, so let's see if there's anything else we need to. Here's some examples of format, and I think these are excellent ones. See, this is the traditional style, the style that we don't want to use. The statement for professional services which you will find enclosed herewith is, in all likelihood, somewhat in excess of your expectations. In the circumstances, I believe it is appropriate for me to avail myself of this opportunity to provide you with an explanation of the cause therefore. Now, you probably know what he's getting at, but gosh, he used an awful lot of words to get there. Here's the plain version. The bill I am sending you with this letter is probably higher than you expected, and I would like to explain why. This is much easier to understand, it's much shorter, and you're much less likely to tick off the person. If the person who received the bill reads this, he's like, oh my gosh, I'm ticked off at this writer of the letter for writing such an obtuse letter, and he's sending me a bill I don't like, so I've ticked him off twice. At least this way, I'm not ticking off the person who is reading this letter by my style. So think about making it straightforward, especially when you're dealing with your client. And then here are some other suggestions. Write file reference numbers. It's a good idea to include both your file number and the reader's file number if you know it. You don't always know your other person's file number, but if you receive letters from them, very likely they've included their file information. It's a courtesy. You don't have to do it, but it sure is nice. Here they say you don't have to use Ray or subject, and it is true. Your law firm's format may not include this. Ours, however, for the purpose of this class, does require that you use RE, capital R, lowercase e, with a colon, and then the subject. And close with care. Again, for the purposes of our class, you can use sincerely, or you can use very truly yours. Either one would be fine. Here it talks about salutations. If you don't know the name of the person that you're sending the letter to, you can use a title such as managing partner. Or you can just use the name of the law firm itself. Now, this piece of advice here I don't agree with. It's obvious that Barbara Ward is a woman. It's not an ambiguous name. And so really you ought to send it to Mrs. Barbara, or Ms., excuse me, MS, period, space, Barbara Ward, Personnel Administrator. And you should say, Dear Ms. Ward, MS, period. Even if you happen to know that she's married or that she's single, you should still use Ms. unless you happen to know she prefers Mrs. or Ms. Your default setting should be Ms. in a professional letter. Obviously, instead of sending it to Dear Sirs, you ought to send it to Ladies and Gentlemen, because obviously Dear Sirs suggests only men are going to receive the letter. Unless you are certain that your audience is completely male, you ought to include ladies in it. Or you can obviously use the name of a department. And I'd like for you to read the rest of this letter, but I think these are the main points that I wanted to talk about. We're also going to go to the Purdue OWL resource. First thing to note here is while this is a perfectly lovely letter, it is in block format, and we are not using block format. So let me just talk about the things that would be different. This would be centered. This would be, it would start on the middle of the page. You would tab it till you get to the middle, and then the address would be here. I'm going to assume this letter was sent by first-class mail, so that's why it doesn't have indication of how it was sent. Then you're going to put Mr. Ernie English here, not just Ernie English. You're going to have a ray line, which you're going to indent, capital R, lowercase e, colon, space, and then the information. Dear Mr. English, this is fine. You're going to indent each one of the paragraphs, although you are going to have this double space here. Yours sincerely or very truly yours will start in the middle of the page. Lucy letter would be right below here, and then unless Lucy is an attorney, you're going to want to have Lucy's title below that. So now this is what they're describing as modified block format, but this isn't the modified block format that we're following. So just because it's called modified block and we're calling ours modified block doesn't mean it's the same thing. There's lots and lots of variations upon this. This is called semi-block, but again, this is actually pretty much what we're doing here. So this is centered. You wouldn't want this to be centered, but this is very close to what we're doing. So the takeaway is follow the program that we have, not necessarily the program that they're describing. So we've gone through this one, we've gone through this one, we've gone through this one. Now I want to show you this letter I found. This actually has problems with it, but I think it's useful to look at this one. This is, you won't find this in your file. You can see this has letterhead. This is actually perhaps from an attorney. We're not entirely sure, but somebody who works for Mr. Rogers' neighborhood. Now this is more like block format than modified block. So if we were to make this modified block, we'd move this date over to about here and put the date here. And you can see here they have Ms. Sis Kaplan, so that's the correct format. And they have Dear Ms. Kaplan with a colon, that's correct. Now they do not indent here, so if you were doing modified block, you would indent until starting about here. But they do have this extra space here, which is good. And this would be indented until about here. This would be indented until about here. This would be indented until about here. You can see the final paragraph. It's just a thank you. You can have a one-sentence paragraph. The sincerely ought to line up with your O in October, so it ought to start about here. Then you have the name of the person, you have his title, and then you have the reference initials. You can see it's capital B and C, that stands for Basil Cox. And then you can see there's a backslash and then lowercase EL. That means that somebody with initials EL actually typed this for Mr. Cox. We'll imagine it's Elizabeth Lawson, EL. That is how the initials are correctly used. So what I'm really showing you here is how this is correctly supposed to be done versus the example we had that was incorrect. Hope that this presentation was helpful for you. We've gone over the formatting of a letter. And let me go to the assignment so you can see what that looks like. So I'm going to go to Learning Modules. I'm going to go to Client Communication. And this is our assignment. Okay, it says to paralegal, of course that's you. The letter is from Janet Cannon. The topic is the deposition of Harriet Day. I have finally reached an agreement with opposing counsel in the Knight versus Day case. Look, we're getting all this information. I'm thinking this stuff will probably go into some reference lines for us. We have agreed in principle to let opposing counsel take Mrs. Day's deposition at this date, and I will take Mr. Knight's deposition 2 weeks later on this date. Please draft a letter to our client, so we know who the letter's going to, and we're going to call her Ms. Harriet Day, for your signature. So you are going to sign this letter. You're the paralegal, so underneath your name you're going to put paralegal, letting her know her deposition is generally scheduled for this date to take place in our office. Please include all the pertinent details and be sure to disclose your roles of paralegal as appropriate in accordance with all ethical guidelines. I will need you to have the client come to our office 1 hour early so I can review the deposition process before we begin. If she has any questions, direct her to contact me when she receives this letter. This is our client's address, and you're supposed to use this particular letterhead. And just remember, I, meaning not Janet Cannon, but Cynthia Gruber, did not accept late homework. Let me show you in the sample documents the letterhead for Miller, Cannon, and Mourinho. It's right down here. So you're going to pull this up. Here we go. Okay, and so you're going to start your letter maybe about here. And of course the first thing you do is you're going to put in your the date, how you're sending the letter, the inside address, the ray, the salutation, the first paragraph, the second paragraph. You're either sincerely or very truly yours, your real name, and paralegal below that. And you should be good to go. Keep in mind this is not primarily a drafting assignment. This is primarily, you've got the material here, you've got the, you're going to have to tweak the language and things like that, but you've got the contents of the letter if you read the memo that Ms. Cannon has sent to you. This assignment is due on Sunday by 11:59. Good luck with it, and thanks for your attention.